Good morning. Welcome to the Children's Bureau's presentation on the Multi-Ethnic Placement Act as amended and Title VI of the Civil Rights Act of 1964. My name is Allison Lowry Palmer, and I'm a Child Welfare Program Specialist in the Policy Division of the Children's Bureau. Let's get started. What will we learn today? We're going to be talking about the requirements of the Multi-Ethnic Placement Act as amended and how those requirements are linked to Title VI of the Civil Rights Act of 1964. We're going to focus on some key MEPA concepts and terms, provide some answers to frequently asked questions, and talk about when race, color, or national origin should be considered, when it may be considered, when it may not be considered. We'll provide practical information on how child welfare agencies and their workers can comply with MEPA and Title VI in their daily practice. And finally, we'll give you information about how to access training and technical assistance. To that end, let's move to our agenda. We're going to talk about federal laws that apply to the consideration of race, color, national origin, and how they interrelate. We'll provide practical guidance, as I mentioned. We'll talk also about the respective roles of the Administration for Children and Families and the Office for Civil Rights, both of which are agencies within HHS. We'll talk about enforcement of Title VI and MEPA. We'll provide some compliance tips, and we'll also provide resources on how to access training and technical assistance, and finally, provide legal, regulatory, and policy authority. Some of the practice considerations that we'll be discussing today include diligent recruitment, denying opportunities to foster or adopt on the basis of RC&O, which is race, color, or national origin, delaying and denying placements on the basis of race, color, national origin, individualized assessments, culture and cultural competence, assessing and preparing parents, request of both biological and prospective foster and adoptive parents. We'll talk about what happens when an agency has concerns about prospective parents as it relates to race, color, or national origin. And then finally, family and community ties, as well as photo listings. Let's turn to the three laws that we'll be dealing with today. First, we'll focus on Title VI of the Civil Rights Act of 1964. We will then focus on Title IV-B of the Social Security Act, which is the diligent recruitment provision. Finally, we will focus on Title IV-E, which is the delay and denial of opportunity provision of the Social Security Act. So to whom do these laws apply? They apply differently depending on the law. For Title VI, which is a very broad statute, it applies to any agency or entity, including state or county child welfare agencies and private agencies that receive federal funds from any source and are involved in adoption or foster care placements. MEPA is a little bit more narrow. It applies to any state child welfare agency or entity within the state that receives Title IV-B or IV-E funds, and that includes child placing agencies and contractors, and any agency that is involved in adoption or foster care placements. Only the state is subject to the Title IV-B diligent recruitment provision. Other laws apply in other contexts, so MEPA does not apply to all adoptions. So for example, in international adoptions, MEPA may or may not apply. And similarly, Indian children who are subject to the Indian Child Welfare Act may not be subject to MEPA as well. So some of the key terms that we're going to talk about today include race, color, national origin. And while that might seem self-explanatory, we do want to provide some definitions just to make sure we're on the same page. In terms of race, we're talking about Black, Caucasian, or Asian. For color, we're talking about skin tone or complexion. And for national origin, we're talking about a child's or a parent's ancestry. That's important because it doesn't necessarily relate back to the child's country of origin, but it is child's or parent's ancestry. Although it's not included in the language of either statute, ethnicity also is included and is a protected class for Title VI and for MEPA. Ethnicity is covered by Title VI's protection of national origin. MEPA and Title VI do not address discrimination on the basis of religion, age, gender, culture, or any other characteristic. It is only limited to race, color, national origin, and as I mentioned, ethnicity through the protections against national origin discrimination. Let me offer a couple of caveats before we go any further. Throughout the training, I'll be presenting examples of different actions that could violate MEPA and or Title VI. These are merely illustrative, and they do not constitute all the actions that could violate these laws. Similarly, Title VI and MEPA apply to consideration of race, color, national origin in all placements, both same race placements and same RCNO placements and different RCNO placements. And this principle applies throughout the entire training. Let's move now into the substance of the law. We'll focus on Title VI of the Civil Rights Act of 1964. And before we begin, I'm going to give this slide for reference purposes for those that are interested, but please understand that we will talk about these and sort of translate it throughout the presentation, so it will make more sense as we go along. Title VI, as I mentioned, is a very broad federal statute that prohibits discrimination on the basis of race, color, or national origin by recipients of federal financial assistance. Some of the examples of discrimination prohibited by Title VI include denying a service or benefit on the basis of RCNO, which is race, color, national origin, providing services in a different manner based on RCNO, restricting the enjoyment of an advantage based on RCNO, treating an individual differently on the basis of RCNO in determining whether he or she satisfies a requirement to be provided a service or a benefit, affording an opportunity to participate in a program that is different based on RCNO, and finally, using methods or criteria that have the effect of discriminating on the basis of RCNO. And as I mentioned, throughout the presentation, we'll make this much more applied so that it is applied to daily practice and the programs that you administer. Let's turn to a key concept in Title VI, which is strict scrutiny. Consideration of race, color, national origin under Title VI is assessed under a strict scrutiny standard. That is the highest level of constitutional review, and as a practical matter, what it means for states is that when a state considers race, color, national origin when making a placement decision, it needs to be very careful that it has satisfied the strict scrutiny standard. Under this standard, consideration of RCNO must be narrowly tailored and justified as necessary to achieve a compelling government interest. The only compelling government interest that satisfies the strict scrutiny standard is advancing the interest of the child. Strict scrutiny also requires that consideration of RCNO is on an individual basis. So in short, a child welfare agency may consider RCNO only if it has made an individualized determination that the facts and circumstances of the specific case require the consideration of RCNO in order to advance the child's best interest. Any placement policy or any action that considers RCNO is subject to strict scrutiny. Let's turn now to Title 4B and 4E of the Social Security Act. There are two complementary state plan provisions that address issues related to RCNO in Title 4B and 4E, and I will explain why they're complementary after we've discussed the law. Title 4B addresses prospective parent recruitment, and Title 4E addresses consideration of RCNO during the placement process. Title 4B is the diligent recruitment, and as part of its Title 4B state plan, each state must provide for the diligent recruitment of prospective foster or adoptive parents who reflect the race and ethnicity of the children who are in care for whom homes are needed. The state may conduct recruitment activities for the purpose of recruiting parents who reflect the racial and ethnic diversity of the children in care. It also may develop its own recruitment plan, or it may utilize the services of a private recruitment agency that specializes in understanding a specific community or identifying families for specific groups of children. It's important to understand that diligent recruitment provision is not about increasing transracial placements necessarily. This provision really focuses on ensuring that there are prospective families in the foster parent and adoptive parent pool whose race and ethnicity reflect that of the children in care who need homes. In conducting diligent recruitment activities, the state must allow prospective parents to participate in general recruiting, irrespective of RCNO. The state also must accept applications from prospective parents who are not from one of the communities that the state currently is targeting. And they must include those people in their general recruitment efforts. Finally, the state has to accept applications from prospective parents who do express interest in providing a trans RCNO home for a child. And those applications would just go into the general foster parent pool instead of a pool of diligent recruitment placements. Components of a diligent recruitment plan might include a description of the characteristics of the children in care. And that's, of course, an important point, because unless you understand who your children are and the race and ethnicity of the children in care, you won't be able to recruit parents whose ethnicity and race reflects those children. You also want to use specific strategies to reach the individuals and communities that do reflect the children in care. Use diverse methods of disseminating general and child-specific information. You can be creative with media, with church, with civic, religious organizations. Make sure you have strategies for ensuring that all prospective parents have access to the home study process. This includes making sure that fees are not discriminatory, making sure that applications are widely available, not just online, make sure that there's obvious and accessible transportation to reach your offices so that people can apply to be a foster or adoptive parent if they wish to. And finally, make sure you have strategies for training staff to work with diverse communities and for dealing with other issues that might come up, including linguistic barriers. Let's turn now to Title 4E. These are the delay and deny provisions with which you might be familiar. A state or any entity in a state that is involved in adoption or foster care placements and receives Title 4E funds from the federal government may not deny an individual the opportunity to foster or adopt a child on the basis of the child's or the parent's race, color, or national origin. The state also may not delay or deny a child's placement or entry into foster care or adoption on the basis of the child's or the parent's RCNO. Let's focus first on denial of opportunity and what that means. What that means is that if an appropriate placement for a child exists, an agency may not refuse to place a child with a prospective parent because the parent's RCNO is different from the child's RCNO. And very similarly, the agency may not fail to place a child with a prospective parent because the parent or child is of specific RCNO. This harkens back to what I was saying earlier, which is that MEPA and Title VI apply both to trans RCNO placements and same RCNO placements. The agency may not remove a child from a prospective parent because the parent or child is of specific RCNO, and the agency may not refuse to conduct a home study because the parent or child is a specific RCNO. Let's talk about delay and denial now. If an agency has determined that an appropriate placement for a child exists, the agency may not allow the child to remain in shelter care or some other temporary placement or require a holding period in order to find a particular RCNO foster care placement. That would constitute an impermissible delay. Similarly, the agency may not remove a child who is doing well in a pre-adoptive placement in order to place the child with a family of a particular RCNO. That would constitute an impermissible denial. The agency may not switch a child from one foster placement to another in an effort to place the child into a particular RCNO placement. That would be an impermissible denial. Even if the agency reverses itself after the fact and places a child with the original pre-adoptive family, the agency still would have impermissibly delayed and denied the child's placement into care, and that would be a violation of MEPA and Title VI because it would be an impermissible denial and an impermissible delay. Now that we've gone through the law, let's move a little bit into the more practical aspects of what you need to know when developing your child welfare program. Of course, understanding and placing a children in accordance with a child's needs are at the core of what you as child welfare agencies and social workers do. These individual assessments also are at the core of MEPA and Title VI, and it's important to understand how they relate to these laws and how it's important to apply the individualized assessment process in accordance with MEPA and Title VI. Because workers and agencies best know the children at issue, the agency, of course, has the flexibility to determine which factors it will consider when it's individually assessing a child to figure out what placement is best. But it has to do so in accordance with the law, specifically with Title VI and with MEPA. HHS is not going to tell agencies which factors to consider. However, let's talk about what happens when it becomes necessary or when it becomes apparent that RCNO might need to be considered when placing a child. In that circumstance, the agency would need to individually assess the child to determine whether considering RCNO is in the best interest of the particular child in light of that child's particular and unique circumstances. The agency cannot rely on generalizations or stereotypes about the child's needs based on child's membership in a particular RCNO group. And it's also important to remember that the agency cannot routinely consider RCNO during the individualized assessment process. As I mentioned, the workers are best positioned to know what a child needs and is best positioned to figure out what the best placement for a child is. Any number of factors can be included, but some of the factors that might be relevant when considering RCNO are whether the child has a unique or unusual history, for example, a history of trauma that relates to RCNO, and then really any other factor that the worker believes is necessary to the individualized assessment process. And that, of course, would be based on the worker's individualized and full knowledge of the child and the child's needs. Let's talk about the age to consent to adoption. Some states have law or policy that establishes an age at which a child or youth must or may consent to adoption. If your state has such a law or policy and an agency is placing a youth who meets that age that the youth requests or refuses a placement on the basis of RCNO, the agency may honor such a placement or a refusal without violating MEPA or Title VI. So again, if a child who meets the age of consent requests a placement on the basis of RCNO or refuses a placement on the basis of RCNO, the agency may honor that request or refusal. In such a circumstance, the agency should document its determination of whether the youth's request or refusal is in that child's best interest. Nonetheless, even if the agency disagrees with that youth's assessment and that request, the agency may honor the placement if it chooses to do so. Now, in circumstances where your state does not have such a law or policy, or if your state does have such a law or policy, but the child does not meet that age to consent, the child's request may not be determinative, and the agency must be very, very cautious in considering a stated preference. In that circumstance, the agency would need to look at all of the relevant circumstances as part of the individualized review to determine whether or not consideration of RCNO is appropriate. So how does a state conduct an individualized review? As a practical matter, MEPA and Title VI, HHS, do not require agencies to seek the opinion of or use outside professionals to conduct an individualized review. However, doing so and securing a professional consultation from a social worker, psychologist, psychiatrist might provide further insight into the child's needs and it might help to figure out what is the best placement for the child. In other circumstances, the agency would just need to conduct the individualized assessment and document it thoroughly to make clear the process and thoughts that it had when making the child's placement. It's important to note that in most cases, a child's best interest can be served without consideration of RCNO. Consequently, it would be rare that the individualized assessment would reveal the need to consider RCNO. But when it does, it's important to document the process, and we'll talk about that a little bit later on. If an individualized assessment reveals that it's necessary to consider RCNO in order to advance the child's best interests, the agency may do so, but only to the extent necessary to advance the child's best interests. So in applying the standard, RCNO should not be predominant. It should, unless the individualized assessment reveals that that's the important point. The agency also would examine other factors that are relevant, such as age, membership in a sibling group, health, education, cognitive or psychological needs that it otherwise would consider. And again, the agency has the flexibility to weigh these factors. So otherwise stated, if the individualized assessment reveals the need to consider RCNO, the agency then can consider it along with everything else it otherwise would consider. It does not allow the agency to ignore any other factors that are relevant to the child. Unless the individualized assessment reveals the need to do so, The agency may not use RCNO to distinguish between two or more acceptable placements, and the agency may identify differences between and among families who are equally well suited to provide care to a child that do not involve consideration of RCNO. All families are different, and so the agency will be able to figure out ways to distinguish between families when RCNO is an issue. Let's move to culture and cultural competence now. MEPA and Title VI do not address the consideration of culture in placement decisions. HHS also does not define the word culture. But what is important to note is that an agency may not use culture as a replacement or a proxy for routinely considering RCNO. That is prohibited. Some of the acceptable non-discriminatory cultural issues to discuss with a family during a home study might include holidays, religion, food, any issue that is not being used as a proxy or replacement for RCNO. An agency may not assess a family's or a parent's ability to parent a child of a particular RCNO through the use of a cultural competence test. And again, an agency should be very cautious when assessing or considering a child's or a family's culture on a home study form or elsewhere. Oftentimes on such home studies, a worker will be asked to examine a child's or a family's culture and whether the family can meet the child's cultural needs. In that case, that is often being used as a proxy for RCNO. So I would encourage you just to be cautious when you see that on a home study form. And for those that are drafting home study forms, to consider being explicit that you're not talking about RCNO-related issues. In terms of assessing cultural competence and the cultural competence test, an agency may not assess or ask prospective parents to assess whether they are competent to parent a child whose RCNO differs from that of the parents. Throughout the agency's interaction with the family, the agency may not ask or consider why a family wants to parent across RCNO lines, what a family knows about RCNOs different from the family's own RCNO, or whether a family's activities reflect a knowledge of or appreciation of the RCNO of the child that the family wishes to parent. Similarly, the agency may not require prospective parents to take different or extra steps in order to parent a child who is in foster care on the basis of RCNO. They may not single out parents who want to parent across RCNO lines or require them to learn different or more things. However, and this is an important point, is that they may provide information to parents that will help them care for the child, such as hair care or any other personal care issues. That, of course, is an important point and an important part of understanding how to parent and take care of a child, and that is not prohibited by MEPA or Title VI. In terms of assessing prospective parents, both through the use of a cultural competence test or otherwise, again, an agency may not allow or create a child welfare process that is two-tiered, that subjects parents who want to foster or adopt a child of a different RCNO to higher degrees of scrutiny. So that would include a longer or more invasive home study process, examining different or more issues for parents that wish to parent across RCNO lines that the agency does not examine for parents who do not wish to so foster or adopt. That would include requests that are specific to families who plan to parent across RCNO lines, such as requiring parents to develop or draft a trans-RCNO placement or parenting plan. Those types of things would be prohibited. Let's move to preparing prospective parents, which is a very important part of understanding and making sure that children are well cared for and that the placement will work and advance the child's best interest. In terms of offering training about trans-RCNO placements, an agency may offer training to prospective parents about parenting a child of a different RCNO under certain circumstances. And that's if it's offered to all parents, regardless of whether the parents plan to foster or adopt across RCNO lines. And it also, you need to make sure that participation in the training is not mandatory or a precondition only for parents who want to pursue a trans-RCNO placement. So what does that mean? That means that the agency requires all of its prospective foster and adoptive parents to take some type of diversity or RCNO training parenting course. That is fine. But what it cannot do is single out the parents who wish to adopt across RCNO lines and make that mandatory for them. If a prospective parent requests RCNO training, the agency absolutely may offer that to the parent, as long as the information is consistent with MEPA and Title VI, and that it's provided regardless of the prospective parent's or child's RCNO. And the agency needs to make sure that even if a parent requested originally, that the agency doesn't pressure the parent to take it. And then finally, in preparing parents, there's a very big distinction between preparing parents and assessing them. So if you're preparing parents to parent a child, that's fine, but you cannot use such a request for help or information about trans RCNO parenting as an assessment or a home study tool. All right, so what happens if an agency believes that a parent might need some information about trans RCNO parenting, but the parent hasn't asked for it? An agency may offer trans RCNO parenting information at its own discretion to prospective parents, as long as the information is made available in the context of preparing and preparation for caring for a child, and not assessing a parent's capacity to parent a child of a particular or a different RCNO. You also need to make sure that consideration of the information or participation in related services is not a precondition for parents who express interest in pursuing a trans RCNO placement. In these types of instances, an agency may prepare a prospective parent to foster or adopt a child of a different RCNO by asking parents to describe their questions or their concerns, their thoughts, connecting parents with helpful resources. And this is where post-placement resources can play a very large and important role. You can offer any type of services, support groups, social groups, any type of information that might be helpful to them, especially post-placement, and that does not violate MEPA or Title VI. Oftentimes, parents will request or seek characteristics in children that are not in care. So if that happens, the agency certainly may tell the parents whether the children who are currently in care and who need homes do or do not have the characteristics that the parents seek. They can, that's age of the child, RCNO of available children, the special needs of available children. And if that happens, the agency certainly should ask prospective parents whether they want to consider providing a home for a child or for children whose characteristics reflect the children for whom homes are needed. That can include telling a parent that there are children of a different RCNO than the parent originally requested. And then in that case, it's just fine, and it's important to discuss with parents the challenges that they might arise, that they might face when parenting a child whose characteristics differ from those of the characteristics that the parents originally sought. Very broadly, it's important to remember that an agency may not discourage parents from pursuing a trans RCNO placement, and they cannot require parents to participate in any training related to RCNO unless the training is required of all prospective parents. Let's move to talk about what happens when an agency has concerns about prospective parents. The reality is that there will be parents who might express interest in providing a home for a child of a different or specific RCNO, but the agency has grave concerns about placing such a child with those parents. In that case, it's very important to remember the key is to advance a child's best interest. So if the agency decides not to place a child or a group of children of a specific RCNO with a family because the agency has concerns that are documented about that family, that is fine, and that does not violate MEPA and Title VI of the Civil Rights Act. So for example, where a family expresses prejudice about people of a certain RCNO but still wishes to foster or adopt children of that RCNO, the agency can talk with the family about those statements. They can delve further into the issues. And after doing so, if the agency believes that the parent should not parent a specific child of a specific RCNO or any children of a specific RCNO, the agency should document its reasons fully, as close to verbatim as possible, and anything that relates to the belief or what happened and the resulting placement decision. A decision that is necessary to advance the child's best interest, including a decision not to place with a family of a certain RCNO and on the basis of RCNO is not a violation of MEPA or Title VI. That simply is advancing the child's best interest, and that is always the key concept here. Let's turn to requests by prospective parents and biological parents. In both voluntary and involuntary removals, an agency may not consider or honor the request of parents or legal guardians to place a child with foster parents or adoptive parents of a specific RCNO. And this applies to birth parents who are considering placing infants for adoption. This goes back to what I was saying earlier. It's very important to understand to whom MEPA applies and Title VI and under what circumstances. Now, this is very different because now we're talking about prospective foster or adoptive parent requests. MEPA and Title VI do not bind prospective foster and adoptive parents. They can make requests about anything they want, including RCNO. And agencies are not required at all to place a child of a particular RCNO with a parent who doesn't want that child or who doesn't want any children of a particular RCNO. It's important, though, to remember that agencies do have to be as flexible with prospective parents' requests related to RCNO as they are with parents' requests about other issues. So, for example, if an agency presents children whose characteristics do not match the parent's requests, the agency must similarly be flexible with presenting children whose RCNO does not match the parent's request. Let's talk about family and community ties and the importance of preserving those ties. As you all know, the Child and Family Services Review assesses whether a state is making concerted efforts to maintain a child's important connections, including ties to community, neighborhood, and school. ACF recognizes that in many cases it's so important to preserve those ties, especially when the child is expected to be reunited and reunified with his or her parents or another family member in the same neighborhood. Making these efforts, these important efforts, to maintain a child's ties does not violate MEPA or Title VI. And finally, let's turn to photo listings. An agency certainly may identify or document the RCNO of a child who is featured on an adoption website such as Adopt Us Kids. It may design and administer websites and adoption listings that allow prospective parents to search on the basis of RCNO. In doing so, though, it must ensure that it treats RCNO in the same manner that it treats any other characteristics, such as age, gender, membership in a sibling group. So if an agency identifies a child's RCNO on the website, it needs to identify other characteristics as well about the child. Or if it allows an agency to search based on RCNO, the website also must allow parents to search based on other characteristics as well. Let's take a quick break for a few moments, and then we'll move into the more administrative part of the presentation.